Well, are you called as expert witnesses in this case? For the audiographic testing from the Criminology Service of the Civil Guard, who are the Civil Guard officers. With professional IDs I-14756-A8-2999, yes. V84113, V44087. And you are Mr. Miguel Angel Perez, yes, that's right. And you, from Tegucigalpa, Mr. Francisco Javier Martin Porras.
That's right, Your Honor.
I'll start with you. Do you swear or promise to faithfully carry out your duties as an expert witness?
I swear.
Mr. Hernan Lopez Mayorales, the same question. Yes, I swear. The members of the Criminalistic Service of the Civil Guard, 82,299, I-84113, I-4487.
Yes, I swear.
Do you know or have any ties to the defendants, the qualifications? No. The degree and the qualifications. I'll start with the members of the Guardia Civil. They are obviously officers of the Guardia Civil. What is their rank? Guardia Civil officer.
Guardia Civil officer. Or first class. Guardia Civil officer.
And you?
I am a university certified expert in forensic analysis and digital evidence extraction from Miguel Hernandez University. And I am also a private expert witness specialized in digital forensics.
Is it? Sorry?
A private expert specialized in digital forensics.
Do you have any academic degree?
No.
Mr. Javier Martin Porras. Yes, that's right. What academic degree do you have? Yes.
I have a degree in law, and I have several official master's degrees in digital forensics, cybersecurity, forensic science, and I'm also pursuing a PhD in computer science.
All right, okay, degree. I have a hierarchy of capital management. No, that's not it. Please answer the questions asked by the public prosecutor.
With your permission, Your Honor. All right.
Excuse me for a second. Are the 4 Civil Guard officers and the 2 experts familiar, respectively, with the report prepared by the Civil Guard's Criminalistic Service and the reports prepared by the 2 attending experts?
No, we in the acoustics department are not familiar with it.
In the acoustics department?
Acoustics department, I mean, we haven't had access to the report from the other experts. We haven't had access to it.
And the other part, the digital one, the electronic side hasn't either. So you don't know the report, let's say, just to call it something to understand it, the expert analysis that was assigned to you and the counter-expert report, the one assigned to the experts who are coming. Do you know the expert report?
Yes, that's right.
And you don't know the content of the counter-expert report?
They've already told you.
Okay. Please answer the prosecutor's question.
With your permission, Your Excellency, sir. Regarding your education, it has already been briefly explained. Your degrees, courses, and training are extensively detailed in your respective reports. I don't think it's worth asking you about that. The first obvious thing is whether the electronic experts from the Civil Guard, the acoustic experts, Mr. Hernan Lopez and Mr. Javier, confirm their respective reports. Martin, the expert report that you have prepared.
Yes.
We'll explain it to you.
Well, I understand that today's testimony is not about reproducing your reports that are already in the proceedings, which we have read and which the court has read and has at its disposal, but rather that you clarify certain points, especially those where there may be some discrepancies between you, and clarify them in a way that is understandable to the parties. That we are not experts in the subject, I certainly am not, and also for the court, regardless of the background its members may have. Let them clarify any points that may be unclear. And if you remember, as the Honorable Investigating Judge told you in this very Supreme Court, your work has a lot to do with translation. Therefore, try to be as clear as possible so that it is understandable for everyone. Either of the two experts in electronics and acoustics from the Civil Guard can answer the questions that I ask you when I address them to both of you. And in the same way, you too, Mr. Hernan and Mr. Javier, can intervene interchangeably, because your expert examination concerns a single subject, unlike that of the Civil Guard, which involves two different subjects. Bien. All right. To you. I am now speaking to the Civil Guard, to the Criminalistic Service of the Civil Guard. Were you provided with a hard drive that contained files from mobile phones, from 3 phones and a recorder? Was that the case? Yes.
Correct. Yes, that's right.
Were you, Mr. Hernan or Mr. Javier, given access to the Civil Guard reports? But were you also provided with the same phones and recorder? How were they delivered to you?
No, we have only been given access to the isolated files.
Isolated files? Yes. What did you select? Who?
What is made available to us through the lawyers who retained us?
Who hires you for the defense of?
Please speak closer to the microphone so it records clearly.
Yes, we asked him.
Yes, Mr. Serdan's lawyer is the one who provided us with all that material, which is what he had available.
And that's the material that, yes.
The isolated files. We don't have the original dumps, only the isolated files.
All right, regarding the electronics experts, the purpose of their expert examination, if you remember, was to determine whether the conversations were recorded directly from the terminals they were provided or if they could have come from other files. Their conclusion, which appears on page 22, is that those recordings are intact, recorded with those devices, and at no point has there been any kind of manipulation of the audios. Do you have any doubts? Any reasonable doubt about this manipulation? No. Regarding the acoustic experts, the purpose of their expert analysis was to determine whether the audio files contained in the police report of June 5, 25 and its annexes are authentic, in the sense that it can be reasonably ruled out that they could have been subject to any kind of manipulation, cutting or editing. I would like them to explain their conclusion to the court because they say it is more likely to observe the results as a whole from the analyses for the authenticity hypothesis to be true than for the opposite hypothesis to be true, because you say that you should not or cannot rule on the authenticity of the recording, as that is something that corresponds to the court, to the judicial authority. Can you explain what is more likely, what probability, what strength that conclusion has? Yes.
With your permission, I would like to raise a point of order. Since those audios being referred to are not part of this case, they are at the Audiencia Nacional, the recorder recordings. So, I would like the court to please limit the scope of this expert testimony because the 6 recordings being referred to, which you are asking about, the AUCO report, are not part of this case. They are at the Audiencia Nacional. So, I would like to know, just to organize the questioning, if we are going to have an expert testimony regarding recordings from a recorder that no one is disputing because they are not part of this case.
With your permission, Your Honor, they requested the evidence. So, I don't understand why we're limiting the scope of the evidence right now, at the very moment the evidence is being presented.
Certainly, you are the one who requested the evidence.
Yes, with your permission, but not about the audio recordings.
Let me finish. Regarding that evidence, the public prosecution in the preliminary hearing insisted that if that evidence was admitted, the evidence that was also in the case would be admitted as well, which has been included and was developed by the Criminalistic Service of the Civil Guard. The content of the expert report you proposed was about the report that was in the case.
Yes, with your permission, but not related to the recorder's audios. When we proposed it, the focus was on us. We want to determine if there was a chain of custody, if they were analyzed, and if the data was extracted. For the audios and WhatsApp messages that are in this case, but not for those from the recorder that are not in this case. I'm just trying to narrow the questioning because knowing if the recorder audios are real isn't helpful if that's not being discussed.
With that limitation of the content proposed by the defense, which was the one that requested the expert evidence, the prosecution can focus on that aspect.
The prosecution honestly doesn't understand anything and can't believe this observation. It's expert evidence sought by Mr. Koldo Garcia's defense. Expert evidence concerning both the electronics report and the acoustics report from the Civil Guard. In preliminary matters, the prosecution argues that if the experts who contradict two reports, acoustics and electronics, are going to come, then the Civil Guard experts who made the acoustics and electronics reports should also come. The chain of custody is not the subject of the expert evidence, starting with the fact that the defense's own expert said that the files were given to him by the defense. So, we can't raise the chain of custody issue there. The files were given to the Civil Guard experts by the court clerk, but the chain of custody issue will be addressed in the evidence next Monday. I understand this is in relation to the Civil Guard officers who carried out the extraction and data dump from these devices. What we're here to discuss is the assessment of whether or not those audios were manipulated according to the expert reports that have been presented. I don't understand what else can be defined there or how I can limit the questioning, which in any case will proceed in reasonable and specific terms. I don't quite understand what the objection is to the evidence requested by the defense. I don't understand it.
With your permission, if I may, I'll explain. I haven't called the officers involved in that crime. I propose that this documentary evidence be admitted in relation to what matters to us in this trial. If the questioning is about the audio recordings from the recorder, which aren't part of this proceeding, I'm sorry, but I don't understand.
But if you have proposed an expert evidence regarding an existing expert report, if you propose an expert examination about an expert report already, and assistant, the accusing party, the party that relied on that evidence, will have to use that means now. The problem now is that the evidence you proposed has nothing to do with the material content of the expert report. Regarding the subject of this trial, we would be left with what you call the chain of custody. But is the public prosecutor right when they state that the chain of custody cannot be questioned? Since the experts you propose have not been involved in the custody and the chain, they cannot assess that aspect. Therefore, the evidence is somewhat lacking in substance.
But the purpose of my expert report, which was not mine, by the way, it belonged to Mr. Santos Cerdan, who is not involved in this case.
It wasn't yours because you proposed it?
I suggested that it be included as documentary evidence in the case for two reasons.
As documentary evidence, it will be similar to the proposed expert report.
Exactly. I asked the experts to confirm their findings, since the report has two conclusions about the recorder audios, which are not part of this case. There are also other conclusions. One is that the chain of custody cannot be verified, and two, that the copies of the WhatsApp messages are in other reports from the UCO. These gentlemen have not worked on those. That is not the subject of their expertise. They were taken from the cloud, and therefore at least. I would like my experts, who are now mine, even though they used to be Mr. Santos Cerdan's, to explain why, if they are taken from the cloud, they are not valid. And since we haven't been given a copy of the phones or a copy of the extractions, what matters to this case is the audio, what's here, which we can make use of from this expert report. Meanwhile, my point of order is because the questions have been directed about the recorder audios and the recorder audios. I'm not sure if you'll know which audios we're referring to if they're not included in the case.
I'm referring to your written submission where it expressly says computer expert report, computer forensic analysis, and meta-expert report. And the audio and the reports issued by the Central Operational Unit and the Criminalistic Service of the Civil Guard within the framework of the case. The second thing is that what you're doing is straightforward, carrying out a counter-expertise to the one that already exists in the case. If that's the case, logically the prosecution must have brought in the experts who reported on the points referred to in the counter-expertise you are requesting. Yes, of course, to put oneself as the prosecutor says, and he's right about this and about other things too. But let's go with this. Regarding what he points out about discussing the chain of custody, traceability, integrity, When the counter-expert report is based on aspects provided by the defense of a third person, it makes no sense at this point.
But that was precisely the purpose of my proposed evidence, not to analyze the recordings from the recorder. I'm raising a point of order because the questions were about the recorder's recordings. The chain of custody and whether we can consider something authentic or not, something taken from the cloud and not directly from the phone, that I do understand is the subject of this procedure. What you have read is the title of the expert report, which before, case 2075 was all together, but it was split up. Part of it went to the Audiencia Nacional. So these expert reports, now I understand in my opinion that they have been separated. On one hand, everything related to the audio from the recorder is going elsewhere, which is not part of this case. You are not going to know which audios they are referring to. The 6 audios from the recorder are not here. So I question orders. Should we ask about the recordings from the recorder that are not part of this case or only focus on relevant ones? Chain of custody.
Do we limit ourselves to what you have proposed?
Well, I've proposed what pertains to this case, but of course I'm not going to propose. We're not going to direct the questioning about something that isn't in the case. I'm bringing it up, of course you have the final say, but you won't even know which audios we're talking about. Thank you.
Let's go.
Vamos a suspender.
5 minutes.
I would like to say something too, if possible.
Let's hear from the parties in turn.
With your leave, Your Honor. I understand that from the beginning there has been some confusion here, which I don't dare attribute to procedural bad faith, but obviously this is a report issued at the request of a third party who is under investigation in another proceeding. His defense attorney in another proceeding requested this expert report on some audio recordings. That is what this report has been issued about. Now, my distinguished colleague is telling us that she wants to extract from these reports not only the audio recordings, not just the information that the reports refer to, but also a theoretical installation in a cloud service that no one has mentioned. Neither in the Civil Guard reports, nor in Civil Guard Report 96, nor in the expert reports of Mr. Zim do they mention a cloud. It also doesn't mention WhatsApp messages. The reports issued by the Civil Guard on this matter do not refer to WhatsApp messages. They refer to audio recordings that are relevant to dealings in the road sector, ADIF, and all of that. So what they're trying to do here is to draw a conclusion that by extrapolation can be used to challenge everything the Civil Guard has done during this procedure. And in my opinion, that's a claim that borders on procedural bad faith, because here we're going to talk about the audio recordings, which is what has brought us here. Regarding those audio recordings and those reports, I understand that we can't go beyond that, nor talk about a cloud or WhatsApp messages or anything else. And that's why I think the most reasonable thing would be for them to withdraw the evidence, take it where it needs to go, and not waste our time.
The public prosecutor seeks to expand the report. Ministry?
No, the public prosecutor cannot say anything further. The expert report is presented. The purpose of the examination is very clear. It's the audio recordings, it's the acoustics, and it's the electronics. There are 2 issues that are being questioned and that are the subject of the expert examination ordered by the investigating judge. Against those electronics and acoustics expert reports, a new expert report is presented, which is the one brought to this proceeding for its ratification. And as I said before, since a counter-expert report was going to be ratified, if we can call it that, the prosecutor's office and the popular prosecution request that the experts referred to in that report also come, those who prepared the report to whom the counter-expert report refers. So I don't see any major problem or any greater implications. The evidence has been admitted, it has been properly admitted, and it just needs to be carried out. I don't see anything else. If you waive the evidence, then you can waive the taking of the evidence. But that's another matter. But the argument, I honestly don't understand it.
The defense, Ms. Aldama.
With the court's permission, since this was not proposed by our defense, we agree with the public prosecutor and will withdraw from the matter.
The defense of Mr. Avalos.
With your permission, Mr. President, we join the request made by my colleague in its strict terms.
The defense, Mr. Garcia de Izaguirre, would like to add something.
Yes, with your permission, Your Honor, I cannot allow this party to be accused of procedural bad faith. Since I am the only one who, at the beginning of the questioning, made it clear that it has nothing to do with the subject of this case. I requested an expert report based on two conclusions that are extremely beneficial for my client, which is that the chain of custody may have been broken and that all the WhatsApp messages may have been extracted, not directly from the phones, but from a cloud. With all that entails, not just the chain of custody, but also evidence authenticity. At the beginning of the interrogation, I made it clear that the scope is much broader, that the evidence was referring to audio recordings that are not in the case file. And I interrupted him as soon as I could, as soon as I heard that the public prosecutor was directing their questions about some audio recordings. I did not present this evidence here in this case to talk about the recordings, which of course mention Mr. Zerdan, but it has nothing to do with this. I cannot allow myself to be accused of procedural bad faith. I cannot tolerate it.
And regardless of the above, it would be enough, if I interpret correctly, to analyze in this police evidence the way the audio and electronic evidence was obtained. And what about fidelity? Well, the court will now retire to deliberate on that matter. We will take a 5-minute recess. Thank you. The public hearing session is resumed. Good. The court understands that once it was proposed by the public prosecutor's office during the preliminary hearing, it is no longer evidence dependent on the evidence proposed by Mr. Garcia Izaguirre's defense. It is evidence that has its own autonomy, and therefore it is the public prosecutor's office that defines the scope of the police evidence. But given the way it has developed, the actual content of this police evidence should focus on what it truly is: how they were obtained, the conditions for preserving the evidence, and the conditions for safeguarding the recordings. Not about the content of the recordings, which are not the subject of this process, but rather those pieces of evidence that concern how they were obtained and the conditions for preserving them. With that perspective, yes, sorry.
No, excuse me, Your Excellency, I think I interrupted you.
No, under those conditions, please answer the questions asked by the public prosecutor.
Yes, with your permission, under those conditions, I have no questions to ask him, because the acquisition, cloning, and extraction of the seized information, the records, the audio files that are on the phones, on the 3 phone devices, the iPhones that were seized from Córdoba Garcia Izaguirre, and the recorder that was seized at the home of Córdoba Garcia Izaguirre, they will be the subject on Monday of the agent's testimony or expert report, E93135C, who will be able to attest to it, along with the civil guard officer. Also, C87609B, about how that information was obtained, those mobile devices, how their contents were extracted, how they were cloned, how they were safeguarded. So these gentlemen have no knowledge of how that was done. They were given a flash drive or a device with the data dump, which was done at the Secretariat of the Supreme Court. And based on that document, they have carried out their electronics and acoustics analysis, which was later contradicted by the expert appointed by the defense of Mr. Santos Cerdan. The purpose of this analysis is the integrity and authenticity from the electronic and acoustic point of view of those devices, whether they have been tampered with or not. But how did those devices get to them? They can't give, correct me if I'm wrong, they can't explain anything at all to the court.
Right, but precisely because of that, when any of the counter-experts we've called want to question that part, maybe the public and popular prosecution, can they formally ask any questions to highlight the contents of the counter-expert report or to bring out the contents of that expert report? Thank you.
With the court's permission, Your Honor, the thing is, this is an expert evidence, and the expert evidence was agreed upon at the time by the investigating magistrate and was limited. to determine whether the audio files contained in the police report of June 5th and its annexes are authentic, it can be reasonably ruled out that they were subject to any manipulation if the conversations were recorded directly on the aforementioned devices, if they were indeed recorded directly on the aforementioned devices. So none of the reports have addressed the acquisition, preservation, or chain of custody. None of these reports are aimed at studying that. What they have studied is whether an audio sounds good, whether the voice belongs to Santos Terdan or someone else, whether the files seem to be truncated or not, and this is what is being discussed. And also from another case. This is the problem with this evidence. So discussing WhatsApp messages and cloud data, which are not in the audio files here, obtaining evidence that is also not in the report that was requested at the time by the Honorable Leopoldo Puente. I understand this goes beyond the scope of why we're here, which is to ratify a report that's already been issued.
Sí. Any changes to what's been said?
Yes, with your permission. I am the one requesting the evidence in defense of my client, in my client's interests. Clearly, these aren't topics for popular conversation.
Excuse me, but the prosecutor has also requested the evidence, and it is independent of what you have presented.
Oh, I hadn't understood that. Regarding the possible withdrawal, if he decides not to call the sacrum officers, of course, that's not my evidence. I'm only interested in my own experts. I haven't called the sacrum experts, and I didn't intend to. I just don't think it's relevant to this case. The report I submitted is because, in addition to those audios, it goes a bit further and introduces 2 key points that could be relevant in this case: the chain of custody, and whether the WhatsApp messages from all the evidence in the reports can be considered authentic or not, since they weren't extracted from the phones, but from a cloud. So that's something that does interest me in the expert report I've proposed. Regarding SECRIM, with all due respect, as I heard you during the investigation phase, they only talked about the famous 6 audio recordings from the recorder, which are not the subject of this procedure.
Once again, sorry, my subconscious betrayed me again when I said the police reports. It's just that these reports have been made based on Police Report 96, and not on the entire police report, but on a very specific type of evidence, which are 8 audio recordings out of all the evidence in a report. The attempt now is to cast doubt on all civil guard reports. On that basis, taking advantage, that's why I said it borders on bad faith. I haven't accused anyone taking advantage of the fact that a report on 8 audios from a very specific case file is being confirmed. They're trying to cast doubt on all the case files, on the entire civil guard police investigation. And that's what I think should not be allowed.
With your permission. There are 2 expert reports, one acoustic, which I have not requested to be ratified, which is exclusively about those 6 audios that I say are relevant to this procedure, in complete procedural good faith, and another electronic one. Regarding the electronic one, the expert report that I have requested deals with both the acoustic and the electronic together. As for the acoustic one, I understand that we have nothing to listen to here, because neither the recorder nor the 6 audios are present. Regarding the electronic one, the other one, if they waive the secret evidence, I will too. I haven't requested it either. As for the electronic one, Santos Cerdan's expert presented a counter-expert report. From the conclusions of the electronic counter-expert report by Santos Cerdan's expert, 2 consequences are established: that the audios and the WhatsApp messages were not taken directly from the phones, but from the cloud. But from all of them, from the extraction, not just from the recorder. The 6 audios are from the acoustic one, and the others are from that report and from the rest. So regarding the methodology for obtaining the audios and WhatsApp messages from the phones, not from the recorder, this part is indeed of interest to us. I want to know if the chain of custody can be questioned or not, and if it can be said or not that the WhatsApp messages that are in this case actually come from the phones or from the cloud. And since we haven't had access to the phones or the data dump, and we haven't been able to do our own expert analysis because we've never been given the chance, even though you already know me, it's not like I've asked just once, twice, 3 times, or even 100 times. I've asked many times, but they haven't given them to me. The only way I have to defend myself is with another expert report submitted for Santos Cerdan, which does address this issue, and I was waiting for them to give me a copy of the phones or a data dump so I could do my own expert analysis. Since that's not the case, this is all I have to defend myself. And from this, 2 things are very important to my defense. The WhatsApp messages we're hearing, the snippets from a WhatsApp that, for example, my client doesn't recognize, are they authentic or not authentic? Was the chain of custody preserved, yes or no? This is extremely important to this defense's rights. And then,
with your terms and all due interest proposed to you.
Well, given the fondness for success, let's begin with the prosecution's evidence in the terms that have been proposed.
Very well, with your permission. We had started the procedure. I had asked the electronics experts if they had any doubts. About whether the audio recordings that were given to them, the ones recorded on those devices, had undergone any kind of manipulation. They said no. And to the acoustics experts about the authenticity. He asked them about the probability, which you express in terms of probability and not authenticity. I had asked you, I don't remember if you had answered yet, I think not, to explain those terms of authenticity, probability, how you handle them.
Our conclusions are presented from a methodological point of view within our forensic field, forensic acoustics, as a contrast between two hypotheses. There would be one hypothesis in favor of authenticity and another hypothesis against authenticity. The way we work is by looking for evidence that weighs on one side or the other throughout the report. We keep finding samples. And in the end, after all the studies we have carried out, which are recorded throughout the entire report in the whole procedure, our conclusion, which is this, can be summarized as follows. After all the tests we have carried out, we have not found any indication that would lead us to believe that the hypothesis of manipulation prevails over authenticity. So what we want to say is that the strength of all the tests we have carried out makes the hypothesis of authenticity the one that is considered true. We have not found any evidence indicating that there has been tampering.
The audios.
Regarding these audios, the defense's experts raised some objections concerning several audio files that share the same modification date. Which for them would mean that there are simultaneous exports, mass encapsulation, container reconstruction. And there's another aspect that draws the attention of the defense's experts. In some files, they detect the simultaneous presence of signatures corresponding to two different versions of the operating system, from which they deduce that the latest operating system referenced did not exist when the recording was made. Since I have summarized it, but probably incorrectly, I would like you to express those doubts you have about the evidence. The conclusions of the civil guard experts, so that, if appropriate, they may challenge them. If you or your colleague would like to, Your Honor.
Your Honor, I just want to know which audio files you are talking about. Sorry.
Do not interrupt the prosecution again. The development of this expert evidence is already complicated enough without interruptions. When it's your turn, you will speak.
All right, you, Mr. Hernan.
If I understood correctly, the first question refers to what the secretary of the civil guard calls a rollback when they analyze those audio files. That's why there is, or they consider that there is, or they give the explanation for those dates, times, and seconds, because they are exactly the same. What we are saying is that there is no scientific literature that supports that fact. They do report a log of that restoration, which makes sense if that restoration occurs, but that restoration does not include the files that were being synced with the device. If that were the case, there would need to be more elements, not just exactly in those 6 or 8 audio files that are exported at exactly the same second, at the same time, on the same day, but there would have to be more elements inside the device that suffered that damage. And that is neither justified nor provided in that respect.
Y la segunda es en relación...
Maybe, if you agree, let's go in order, because I've given you 2 objections that have nothing to do with each other. They're different, is that correct? So the two objections that I have presented to you very briefly are two different objections. You have now referred to the first one. That is,
that the rollback would not affect all those files that the civil guard says are produced by that rollback. We say no. That is not the reason. I mean, that is not scientifically proven, nor is there any literature to support it.
if you agree, before giving you the opportunity to challenge or clarify that second objection, let's finish with the first one. I understand this is more a matter for electronics experts, right? I'd prefer that you answer if you consider yourself in a position to do so.
In our report, on page 12, we explain in detail and scientifically that by reading and interpreting the system logs, we see how there was an iOS system update that failed, okay? It's true that it failed, and that's why the system itself then returned to its original state. So here, in this part, we explain in detail and scientifically how the system recorded that on October 18th, 2019, around 4:25. Vale? It was able to modify those files. But what was changed was the metadata, not the actual file itself. That's why all those files are the same. Vale?
So I understand that. Oh, sorry. Yes, no, excuse me. I mean, they share the date, let's say, because there was a failed operating system update.
That's right. When the system tries to perform an update and it turns out that the update fails, the iOS system itself returns to its original state. And those files, let's say it's not that it modifies the actual audio itself, but rather it modifies the metadata. That's why those two audio files have the same modification date, but it doesn't mean there was any tampering, okay? That's the most important thing.
Javier, I think you wanted to make an observation.
Yes, excuse my interruption with the court's permission. Look, I want to clarify something before we continue regarding this. The report that we issued, which wasn't actually a report, it was a preliminary report, in which the purpose of making this report was to obtain the original extraction in order, in this case, to carry out a technical and scientific validation task. All right? So, unfortunately, here we can't talk about scientific rigor because neither of the two groups of experts has had access to the originals. We're saying that we had hypothetically identified some elements that could be inconsistent with what was stated in those reports. But in order to make a proper assessment with all the necessary guarantees, we needed that original data dump to reach a scientifically grounded conclusion, ensuring the principles of repeatability of the test. As of today, none of these experts, not even ours, and if I'm wrong, let the SECREM experts themselves correct me, can tell us whether any of the parties have had access to the original evidence.
Yes, with your permission. Well, the original evidence is what was dumped, cloned, and handed over by the Secretariat of the Supreme Court to the SECREM agents. If the evidence that has been handed over, that dump, that clone, matches the originals, we will see, we will analyze it, and the court will have to decide that in its ruling. If the chain of custody has been maintained, the appropriate evidence will be presented by the prosecutor's office on Monday. Well, there is a difference between the handover that was made to the civil guard experts by the court and the handover that was made to you, Mr. Angel, Mr. Javier, and Mr. Hernan, a handover made by one party, one of the defense teams. Apparently, it also excludes some audio files. So there is a difference there. When he says that the civil guard experts have not had access to the information to the original extraction, that is what needs to be done.
Is that so? Did you receive the originals from the court secretariat?
It was actually us who came to make copies of the extractions that were included in the case.
Go ahead.
Insisto, es una cuestión ajena y distinta a la que estamos tratando hoy. No sé si si ha quedado ya claro. Voy a continuar con las objeciones que hacen al informe pericial de la Guardia Civil. La segunda objeción que ustedes hacían era
The simultaneous presence of signatures corresponding to two different versions of the operating system. I'm sure you'll be able to explain it better. What is that objection? And I would also like the SECRIM experts to be able to comment on that.
Yes. Anyway, following up on what was said before, that is the only way to verify if those files that have been exported, batch edited, the only way to see if there has been any kind of alteration or if it was actually because of that rollback would be to access the original dump and analyze all the logs, not just those audio files exclusively. Which interestingly are the only ones that have been affected. There should be many more affected files and more traces left, not just in those files. All right? And regarding the operating system, we want to say that we do not agree with what has been mentioned about the operating system. The operating system that appears is later than the one in place when that recording was made. What we are told is that there is a synchronization of the operating system, and that's why that operating system appears, which did not exist at the time. So, when a basic synchronization is done, either due to a device change or an operating system change, there is no change in the operating system. All right? If there's even a minimal change in that file, I'm talking about the files we've analyzed, maybe some trimming, some indexing, the operating system does change. To give an example and to make it clearer, if I make a voice recording in 2018 and I don't touch it, I leave it as it is. On my phone, on my iPhone, and I keep updating the operating system and changing the phone. Generally, the operating system doesn't change as of today if we do an analysis. It will show us the operating system that was used when the recording was made. If I make a recording in 2018 and in 2020, for example, if I modify that file or if I inject it into a phone, then the operating system at the time I make that modification, manipulation, or alteration of the file will appear, even if it was originally created earlier. What iOS does is overwrite, it gives it a path. And that's why we don't agree. Basically because we can't analyze beyond that since we don't have the original dump and we're very limited when it comes to doing the analysis.
With your permission, excuse me, forgive me for interrupting like this. I respectfully ask you, I don't know.
Don't worry, please go ahead.
Look, something happened, and this is regardless of the parties or the considerations of each of them. We must state that we are talking at all times about the dumps, and they are being considered as originals, and no one disagrees with that. The point is, the extraction is one thing, that it is carried out at a specific moment in court, and another thing is the evidence that it must contain here. Was it recorded on that device or not, or how did it get onto that device? That's what we're questioning because we don't know. And for that, we would also need to have had access to the original device to repeat the test and see where it might have come from. It's not about arguing, at least in our opinion, excuse me, in the end it's the court that will decide. But we are not arguing that there is any problem with that extraction, nor that the civil guard has done anything out of the ordinary. They are great professionals. What we don't know and what we can't prove is how those recordings ended up on that device, whether they were recorded on that device or if they came from a cloud, an injection, or other sources. That's the gist of what we set out in the report.
Perfect. Yes, exactly. That is the purpose of the expert report. If those recordings are original, if there are signs of manipulation, or if they could have been injected, exported, or injected, I don't know what you call it, from other devices, or recorded remotely, or by artificial intelligence, or by the Pegasus system, or God knows in what way. So I'd like you to address this second objection the defense expert raised about evidence of a different operating system. And then we'll move on to the other issues that Mr. Javier referred to.
Regarding the audio recordings, when a regular user starts recording this particular application under study, what it does at the same time is create another audio file that is not accessible to the user and is saved on the device itself. That file, which is not accessible to the user or through any other science fiction contraption, has the same hash as the original audio file. Later on, a record is created in the application's own database where the creation date and duration are stored. Okay? Later on, at the same time, a specific WAV file is created again. That is, when we listen to that audio again, if you can see the waveform of the conversation, those three threads are launched simultaneously when the recording starts, and they are all interconnected through metadata, which makes it almost impossible to access the device remotely or inject any kind of tampering into those audio files. What's more, these audios in question, which they're saying that the metadata modification date could have been changed, are linked to an account. To a user account, kogeis@hotmail.com, I think. In turn, those correspond to the iPhone 8 Plus device. In turn, 2 months later, they appear linked to the same user account on the iPhone 7. What does that mean? That if the first audio from the iPhone 8 Plus had been tampered with on the iPhone 7, there would also be a discrepancy, which means there is no discrepancy. In other words, the audio files are completely intact and there has been no tampering with them.
What about the fact that two fingerprints from different operating systems appear? How do you explain that? Or, as I said,
that basically, most likely. In one version of iOS, a watermark from the app itself is created when the recording is generated. It creates a watermark that later on might be re-encapsulated and keeps that iOS version. But that's done by Apple's own app management. I mean, that's intrinsic to how the internal programming of the app has been done. But that doesn't mean it has been moved from one device to another, manipulated, and then reintroduced into that device, because that's completely impossible. Because there would have been traces. I mean, that's because you would have to manipulate a lot of files, which is not the case.
And if I may, let me give some context on this. In the lab, we injected a voice note from one iPhone to another iPhone. When we inject that voice note into the new device's own voice notes, it already appears physically inside that device. If we analyze only the device by looking at the deep metadata, it's not something a user can see. We can indeed find evidence that this audio does not come from that phone. But the moment we synchronize that injected audio into another device automatically, what we have observed is that iOS gives it a completely valid, verifiable path. And the only way to be able to see that it comes from another device would be by performing a forensic file system dump on the terminal to actually check in the database in the UAL if any kind of alteration has occurred or if that file has been injected.
and have you found, and also for you, Mr. Javier, any indication, any element that would allow you to suppose or infer that a file has been injected into the phone?
Here is an element that The colleague, the forensic expert from SECRIM, has spoken about the issue of metadata, etc., and that it would be detectable, etc. But here we have one thing, which is that this update or supposed update can never be from the future. I mean, we found an operating system fingerprint showing that that operating system did not exist on the recording date of that audio. So that's where the discrepancy is. It's strange. It's strange.
Do you have any explanation for this?
To add to that, from the acoustic point of view, in our part of the acoustic metadata study, when we study the file in hexadecimal mode, specifically the end of the file in hexadecimal mode, it means looking at the details of the file. Bit by bit, looking at the bits, we see a field of which shows us that this file was present in a version of iOS 12.2, which is what we, in the end, support in our hypothesis, that this file was recorded with that iOS 12.2, from which a metadata trace remains. And then, when that failed update happened, in which metadata was overwritten, and then it went back to the original version. Let's say that the system that was recorded, the new version of the new iOS, the one that is later in time than the recording. But that doubt we had at the beginning, and that we actually raised, and that became a point of study for us, we resolved it. In the sense that we found that metadata where it states that this file went through a device that had iOS 12.2, which was consistent with the file's recording date.
I want to mention that what we're saying, deep down, we're saying something similar, but there's a nuance, meaning the update appears. That new operating system in this case is iOS 13, because at first we haven't been able to analyze the full dump of the device. It doesn't happen during a basic synchronization, which shouldn't occur. That is, if that file is not modified or injected at any point, in principle. As of today, it should still have shown iOS 12, but when there's even a minimal modification of the file, that's when that change happens in iOS. We've also done that ourselves in lab tests. Files from the years 2012 and 2014, currently they still appear with the iOS from that date. Even though the device has continuously gone through updates, these are complete files that have never been touched.
Entonces no aparece.
No iOS has at any time been injected or suffered any kind of manipulation, and in the end we come back right now to mention the option here. To preserve that evidence, it would be necessary to analyze that complete forensic dump to see what other elements can help us understand whether or not there has been any kind of alteration in that file.
I'm not sure I understand. Is it because you haven't seen all the files?
The limitation is that we only have the files in isolation. That's why I'm saying
that you don't have all the
files, we don't have or haven't had access to the dump.
You have seen all the files, right? Yes. There's another possibility, sorry.
Excuse me, I wanted to clarify something. I don't know how you could have done that check with an earlier iOS because those devices that are already updated don't let you install an earlier update to do checks.
We wanted to do checks with an earlier version of iOS, quite a bit earlier, in this case version 13.
And it's impossible because Apple doesn't give you the option to
downgrade the update.
Because we have devices that are not updated.
Well, I don't know. So that test doesn't make sense to me, honestly.
Is there another question that was raised regarding these? With these recordings, is it possible that a third party could remotely cause recordings to be made on the device? On Mr. Koldo Garcia's phone from a distance remotely, is it possible for someone to be recording on another person's phone?
Everything is possible in this life, especially in computing and electronics. Our objective in the expert analysis was to find out if recordings had been made with that device. Our objective was not to conduct any other type of analysis, therefore it cannot be determined either way. It is very unlikely given that let's say the application was used at that moment and you can see the usage logs, that it could be run from outside, there could be spy applications that could do it. Our software did not detect any.
Would the user see it, in any case, that recording on their phone?
They have to see it on their phone, obviously, like everyone else. That is, if they don't make a remote recording, that recording won't show up for us. We didn't do this ourselves.
Would the user see it?
Exactly.
All right, thank you. No further questions.
Thank you. With your permission, Your Honor.
I need to record it for the popular prosecution.
With your permission, Mr. President. It's my turn to speak second, and I want to go back a bit to see what the purpose of the expert report was, what each person was able to examine. Because I was surprised that Mr. Cardan's experts say they haven't seen all the files, so my first question to them is, which files have you examined?
Yes, look, to answer your question, in the scope of our expert report, you can see that it has two angles. The study of the audio files in isolation that the defense gives us, which I understand are taken from the proceedings, but also to do a meta-analysis of the police report in order to be able to reproduce. So our conclusions are aimed at determining. Rather, they are aimed at saying that we have found a series of indications and that it is necessary for us to repeat the test in order to clarify or help clarify the facts. That is the scope of our assignment. ¿De acuerdo?
I asked which files you've seen, but you haven't answered.
The files that were provided to us, I think my colleague will have them more readily available, but there were 6 files, 6 audio recordings that were given to us. The defense of Mr. Cerdan?
6. The Civil Guard's report referred to 8 files, because they gave them to you correctly. First, discrepancy. Second, who gave you those files?
The defense's defense. I don't remember right now. There are 2 attorneys.
You don't remember, and how did they give it to you? Sorry, where are you going with this? That's too far afield.
The defense? The other expert who participated in the report can answer the questions.
That initial procedure was done by my colleague. Couldn't I, just on that point, be the one to tell you?
Well, let's ask another question, and then when we get back to that topic, we'll continue.
See, with your permission, sir. So you examined 6 audio files?
The ones we mentioned in the report?
Okay, you haven't examined any WhatsApp files?
None.
Okay, those audio files, did they say which Civil Guard report they came from?
Yeah, we mentioned it in the report. They are related to Santos Cerdan, and we also attached it in the report.
96 of 2025 from the Civil Guard? Yes, that's right. In that report on page 3, you say, what is the purpose and what is the material you have had at your disposal? And you mention report 96 of 2025. Criminalistics report, electronics testing area report, testing report, acoustics area. However, in the scope of this expert examination, they don't mention the recordings. They forgot to include what they examined because they didn't list the recordings. Report.
Could you repeat that, please? No?
On page 3, it says, subject matter of the expert examination. Technical expert analysis and evaluation of the following reports. Central Operational Unit Report, 96-2025 Forensic Report, Civil Guard. Two of them are present here, but the recordings are missing. In your explanation of the subject matter of the expert examination, don't you mention the recordings you have examined? And that's why I was asking you, how many recordings are there?
Are they included in the report?
Let me finish the question. You'll have time to make your objection.
Those recordings are not included in the report because the report contains many others, and that's probably why...
I stopped responding to the expert.
Yes, but no.
We mentioned those recordings that are included in the Guardia Civil Police reports.
Therefore, you have only made your report based on the reports that the Civil Guard has previously reviewed?
Of course, we are only provided with those reports and some files.
All right, you told me you haven't seen any WhatsApp messages. Have you examined any cloud storage? Files that come from any cloud storage?
No, none.
None.
We already have the expert, sorry.
But the connection must have been cut off. As soon as I could...
I was asking you who gave you those files.
Well, the defense gave them to me. What I couldn't specify is which one, because we spoke with both lawyers who were handling that defense or co-defense, and right now I couldn't tell you which of the two. But anyway, I think it was Jacobo, I'm telling you. But right now, I don't remember if they sent it to us through a flash drive or if they sent it to us through a platform we have set up for that kind of duty, or a data transfer service, but I couldn't confirm that for you right now.
In any case, the delivery wasn't in person. Did you receive it? You can't remember if it was through a flash drive or an online platform?
Sí. We had an in-person meeting a few days before the assignment to evaluate the case, but I don't remember being given anything in that meeting, just the paper report.
And that, well, whatever the medium was, it contained the reports plus the 6 files.
It didn't contain the 6 files. We were only given the reports in paper format, and then later, days after, we requested additional reports, the ones indicated in the report.
And didn't Mr. Cerdan's lawyers tell you that there was an official extraction carried out by the court's senior legal officer? That it had been delivered to the parties and also to the Civil Guard, which was the original extraction from the devices? No, they didn't. Only with all this, the lawyer who commissioned your report
did tell us about it, and we know about it, but that's what I was mentioning to this court earlier. The extraction, that extraction was performed on some devices, okay, that had previously been extracted before and were in. If I'm not mistaken in this case, understand that I don't know exactly how the events unfolded. What interested us was not the extraction. What interested us was to repeat the extraction. Because, as my colleague has rightly said, the methodology used by the Civil Guard, I understand, is correct. But could it have been complemented, or could it have been much more extensive? If you do an FFS extraction, it's a bit more complete, right? So, our idea, in our interest, from the very beginning, was to repeat that process. I mean, to have those devices handed over to us, or to do it at the courthouse, or as your honors would have decided at the time. And our approach was to repeat the extraction, to be able to obtain that data that maybe our colleagues could access, and to be able to review and refute it. Because there were these inconsistencies that had been detected, which, on the other hand, are not inconsistencies that we detected ourselves, but rather inconsistencies that appear in the police report itself. Obviously, we haven't been able to repeat the test, so we can't find them, but we have identified the data they do provide. And we have been able to make an alternative hypothesis based on the data from the police reports themselves.
What I was asking you is the origin of the information you have received, because the defense of Mr. Cerdan was given an original extraction, and I wanted to ask you about that. Members of the Civil Guard who are present here have said that they were present during that extraction. I understand. I think I remember that the original devices were brought in. That is, the mobile phones and the recorders. Or was the work already done with a previous extraction that the Civil Guard had made? No.
We came here to the office of the court clerk to collect a copy of those extractions. The extractions were done by the UCO.
The record shows in any case the chain of custody is perfectly documented. The one that is not documented is yours. And that's why I'm asking you,
No commentary, just ask questions. Do not make comments, just ask questions.
if you say that you don't have access to the dump and therefore can't make a report, you never thought to ask Mr. Jacopo Tege to give you what he had submitted to the court.
Excuse me. It's in our own report. We requested it. That report is addressed. That preliminary report is addressed to the legal representation, not to your honors in the report, which is a preliminary report. We send it to you stating in our request what we need. That dump, the use that the respective defenses make of it, excuse me, but understand that it's not our responsibility.
You asked the person who assigned the report for the dump, but they didn't give it to you.
Okay.
The expert has made a statement, he made a report, and it reached its recipient. From that point on, the expert is no longer responsible or can no longer say what was or wasn't done with that report.
And finally, regarding these experts, one question that perhaps should have come before all my other questions. Are you aware that Law 12/1986 on the regulation of the professional powers of architects and engineers grants these professions exclusive rights? The task of preparing expert reports like the ones you have presented here?
We are aware of it, but I disagree with your interpretation, and in any case, your honors have to review it. Because we have not prepared an architectural or engineering report. We have done a meta-expert report, a digital evidence report, which is what we are talking about. I am certified, and I don't even know if my fellow police officers meet those requirements as well.
The qualification of the experts is already part of the case.
Yes, I know it's already part of the case. I just want to know whether that is enough to issue an expert report of this nature.
But the expert won't assess that sufficiency.
Well, I wanted to ask Mr. Francisco Javier Porras. You have been sentenced to 8 years in prison by the Supreme Court for counterfeiting currency and computer equipment, and you were later pardoned by the government of José Luis Rodríguez Zapatero. Does this compromise your credibility as a computer expert in any way?
Maybe I shouldn't be the one to answer that question. Rather, that credibility will speak for itself in the end. Your honors will have to determine that in any case. Let me tell you that the events you referred to happened more than 25 years ago, and after those 25 years, well, maybe things are different now. This expert has been collaborating with various justice administrations, both in Spain and in more than 19 other countries. Within an international organization focused on justice system cooperation and implementation.
Is it enough? Is it enough? Yes.
All right, and regarding the civil guard experts, have you detected any mark of tampering in those files? Any indication that would suggest those files have been tampered with?
Of all the audios and along with the study, from the perspective of the database that is recorded as the recording is created, we have not found any indication that would prove there has been any kind of tampering in those audios. In fact, I also wanted to make a small point because my fellow expert said that the dumps were not FFS, but they were FFS, meaning they were systematic. The full file system extraction, which is the most that forensic tools are able to extract from the devices.
From an acoustic point of view, I wanted to clarify that after all the tests we have carried out, we have not found any signs of tampering in the recordings.
Okay, and finally, regarding the hypothetical external injection, it is not known which systems in a device. Mr. Zerdan's experts say that it is clear that in any case, these processes took place before the devices were seized. At least they say that it was not the civil guard who did this, if there had been any tampering, which does not exist. Is it possible that the devices, once seized and kept in a bag at the civil guard's facilities, could have some system, file, or audio injected into them there?
If they are in custody, it's impossible.
Depending on the bag you mentioned, which is a Faraday bag, and if the device is properly disconnected, yes, there would be no risk of external connection if it's a Faraday bag. If it's not a Faraday bag and the device is on, there is a risk of external contamination.
But you say it's obvious that it would have been done before the seizure. They are categorically admitting that in no case has this been done after the civil guard had those seized devices in their possession. It's on page 20 of your report. It's clear that in any case, these processes detected in the analyzed files took place before the seizure of the devices.
Yes.
That's how you say it. All right, I have no further questions.
Please answer the questions from Mr. Aldama's defense.
No questions.
Your Excellency, thank you very much. On behalf of Mr. Abalos's defense. The defense of Mr. Garcia Izaguirre, yes?
With the court's permission, Your Honors. Just to clarify, and since the law 12/1996 has been mentioned, which according to my colleague only grants authority to engineers and architects. Does anyone here qualify as an architect or engineer? No?
No.
At the request of the presiding judge, the experts representing Mr. Cerdan have been asked if they are graduates. But I didn't understand if you were asked. Do any of the four of you have a university degree? No.
No. Amen.
All the questions that have been asked, both by the Honorable Prosecutor and my colleague, are they referring only to the audio recordings analyzed in the report, or have they included elements other than the recordings from the recorder that are not part of these proceedings?
What appears in our reports?
All right. Okay, just to establish where we are. My questions are going to be directed not at the audio recordings, which, with all due respect, are not part of this procedure, but rather at the chain of custody. So my first question is for the experts of Mr. Santos Cerdan. During the home search of Mr. Koldo Garcia, was any MD5 hash function calculated? Sorry.
But the experts have not participated in the operation.
Yes, but since it's in the conclusions of your report, I understand that you are qualified for the task.
Well, let's see. No, exactly. Let me finish. Tell me, where do you collect this material from?
From the attorney's office.
And you are called by the attorney at the investigating judge's request so that you can do this analysis. Thank you. Have you been involved in obtaining these in the seizure of the devices they were obtained from?
Yes. The forensic service has not been involved at all during the search, extraction, or custody of the devices under examination. We have only analyzed the extraction that we formally collected and documented in an official record.
Let's focus on that moment.
Yes, that's actually the point of my question. If they haven't had access to the original device, but instead were given an extraction that was somewhere else. Of course, I'm going to ask the question. All right, taking this into account, that it hasn't been accepted, that the audios analyzed do not come from the home search of Mr. Koldo Garcia. Could a function have been calculated?
Sorry, but you're twisting the premise of my question. You say, taking into account that they don't come from the intervention, they come from the material that the attorney has stored and has given to the experts. But you can't say they don't come from the intervention, because the experts can't say that. They can report on what they've done, starting from what they obtained.
They said it themselves, they just said it, that they haven't had access to the original phones. Have you had access to the original phones? No, so that's it. So, the purpose of this expert report is to establish the chain of custody.
I was absolutely clear that they were addressing the chain of custody starting from the moment the data dump is obtained, which is provided by the court clerk.
Of course, that's not the objective that concerns the defense of Mr. Koldo Garcia Izaguirre.
But this is what the experts can report on.
But the thing is, this question was directed to the experts, Mr. Santos Cerdan, who precisely, sorry.
Now you're saying it's going to other experts.
Yes, excuse me, Mr. President, but if you don't let me finish, either I'm explaining myself poorly or you don't understand me.
No, you're not explaining it badly.
I'm probably explaining myself terribly, but my question is about one of the things I like, well, that interests me. Mr. Koldo Garcia Izaguirre's defense is that these experts point out that everything being analyzed does not come from Mr. Koldo Garcia Izaguirre's phones, but rather from a dump, from another dump. So, since that's what interests this defense, to put that on the table and question the chain of custody. That is the purpose of this questioning, not the audio files.
To focus the experts as well. The experts from the Civil Guard's Criminalistic Service intervene from the moment the court clerk provides them with the data extraction. And the experts appointed through you and by another defense become aware of it through the data that defense provides them to analyze. Any opinion on the chain of custody or anything they can examine has to be limited to what they know.
Perfect. So, considering that you know these audios were not given to you directly from Mr. Koldo Garcia Izaguirre's phone, can you categorically state that the chain of custody has been preserved, yes or no?
The experts cannot confirm that. No, they can't confirm that. They only know what they received when it arrived. They can only confirm their actions based on available information and aren't responsible for the chain of custody. No, but obviously because they are not in charge of the custody of that data, but...
They discussed that in their expert report, which is why I want the court to hear from them.
We'll evaluate the statements in that regard, but they cannot confirm the chain of custody because they have not been in charge of it. And the other experts can confirm the chain of custody for the part where they have been in charge of certain data dumps that were provided to them to make a report. The custody, on the other hand, was held at the court. Yes.
Sí, let's see, Your Honor. The purpose of this expert testimony right now for the defense of Dr. Koldo Garcia Izaguirre is to question whether, with the data analyzed, yes, considering that this does not come directly from Mr. Garcia Izaguirre's phones, which, by the way, this defense has requested on numerous occasions. Without that evidence, whether it can be stated that the chain of custody has been preserved or not. The purpose of this defense, in calling these expert witnesses, is for them to give their opinion. So, my goal is for them to explain here why they cannot confirm or deny that the chain of custody has been maintained. That is the purpose of this evidence. But if you won't even let me ask the question, thank you. To confirm their report and explain why they arrived at those conclusions.
Every chain of custody statement must be referenced to a detection point and an end point. What are the experts for your defense going to inform you about if they have never had custody of those items at any time?
During the investigation phase, I myself was present at the extraction they carried out. I remember perfectly the second expert here on the right, I think so, at the extraction, right? Weren't you the one who was there? Excuse me. No, okay.
But we have never had access to custody at any time.
Okay, I was present at an extraction. Regardless of the timing?
The chain of custody requires a beginning and an end. So the experts you have appointed or proposed as experts have not participated in the custody. They can inform us, they can write reports, but they cannot conduct an expert analysis on that matter.
Excuse me, let me explain for a second. During the investigation phase, counsel gave us some appointments. I thought it was you, but it wasn't.
Questions?
This expert and I myself were present the day the data was extracted to conduct this examination. In the record where the court clerk was present, the experts, at the request of these experts...
Just to lighten things up a bit, I'll ask the question and then I'll reject it, all right?
But you won't let me ask questions.
No, you're not asking questions. You're challenging me. State the question and I'll tell you whether it's allowed or not.
All right. Why, to Mr. Santos Cedran's experts, why do you raise doubts about the chain of custody?
If you can answer that question.
Yes, in any case, Javier is the one who could best answer this statement.
Yes, look, what we are saying is, it's not that we are raising doubts, it's that from the moment, as Your Honor has rightly said, from the moment those extractions are handed over or made, there is no kind of chain of custody regarding what happened before those extractions. And it was also mentioned... Excuse me, Your Honor, I think you were speaking.
No.
Well, just to say that we are aware of them regarding the chain of custody prior to the extraction, And obviously, there's also a lack of obtaining the digital fingerprint of that evidence. At the time of the seizure of Vamos, we haven't seen it because it should have been seized. Or just like the physical and human chain of custody is established and maintained for those involved. The logical chain of custody of the devices should also have been guaranteed from the moment they were seized. And that's not going to show up.
Does that questioning have any basis, or is it just imagination?
No, that questioning comes from, well, my colleagues can say whether the chain of custody for digital evidence must be guaranteed at all times. It comes from technical and scientific concerns and from various guidelines. From the digital evidence guidelines of the United Kingdom, from EMC itself, obviously, with digital evidence, there is a physical custody of the device, a record of who handled it, who it passed to and from, but there is also a digital chain of custody. You have to know what's there. Because during that transfer, especially with a mobile device, until the data is extracted, it could have been remotely wiped or accessed remotely.
But the experts who have been involved have said that they have not observed any indication that would allow them to say there was any alteration.
Otra pregunta.
Was the hash calculated in the lab or where was it calculated? Thank you. Yes, Javier, my questions are for both of you, for Mr. Hernan and Mr. Javier. Can you tell us if the MD5 or SHA hash function was calculated for the mobile devices at the time of seizure, or was that hash calculation done in the lab?
We can't answer that question. We don't know. We weren't present in either scenario.
Okay, they were submitted, but they're not on record either. You also don't have it on record that they were submitted. Thanks.
Of course, not from the moment of the seizure. It's not recorded in any document, but as I was telling Your Honors and the parties before, it doesn't appear anywhere.
Do the original forensic dumps of the phones contain the first bit-by-bit images obtained by the UCO along with their original hashes? No.
I've never seen that dump. I'm sorry, I can't make any statements about it.
Can you certify that between the initial extraction of the phones and their arrival at the screen, there was no copying, re-indexing, restoration, backup, or any other technical intervention on the analyzed files?
Those questions should be directed to the people who did that. We haven't been involved in that process. I'm sorry to answer you like this, but we haven't been involved. I can't certify, affirm, or disprove anything, right, nor deny it.
Does your report state that it is not possible to compare the data dump from Central Investigative Court Number 2 with that of the Supreme Court, since the clerk received a hard drive but does not have the records of the data dumps? Do you stand by this conclusion?
Yes, of course. But the incompatibility is clear because we have not had access to either of them, and even less so to the first one that was done.
Therefore,
we can't compare the two if we don't have either part.
Thank you. Do you know if the evidence bags are Faraday bags or not?
We weren't present, but there are no references to that kind of packaging in any report.
If there were any, they should be in the reports, right?
Yes, in my opinion, yes, but I don't know what protocol or if they applied any technical protocol at that time. I don't know.
With what you have been able to analyze, have you verified that the destination drives were empty before the extraction?
No, I certainly have no knowledge of whether they were full or empty.
It is true that the file processed with CEDA does not have its own recorded hash, which makes it impossible to prove which version was used in each analysis.
I don't understand the question.
That's my conclusion from your report.
There's some term you're not saying or not stating correctly. I don't know exactly which one. If you tell me on which page of our report.
What you're basically saying is that SECRIN's failure to comply with its own standards is a methodological deficiency, right? More or less. Are you saying this, or is it just my interpretation? Maybe it's just my interpretation.
That's what we're saying. I just understood a different phrase. Let's see. This happens in many cases where digital evidence is involved. And it's one thing is what the standards say, and another thing is that in practice, during seizures, everything is done exactly as the standards say, right? In this case, it is not proven that the protocols indicated by the scientific community regarding the seizure, collection, and preservation of digital evidence were followed. They are not reflected in those reports.
All right. Regarding the extraction route from the cloud versus the phone, which is also relevant to this case. Do you know where the audio files were physically stored according to the extraction paths listed in the report, whether in local memory, on the devices, or in iCloud?
Maybe my colleague can answer you more specifically.
Well, even though we haven't had access to those original dumps or to the phones, when the file path refers to the cloud, although that dump or that phone would need to be analyzed, it refers to the cloud, not physically on the phone. That's why, well, it's important to perform a physical extraction from the phone rather than from the cloud.
Okay, what's the difference in terms of authenticity between a file extracted from the phone's internal memory and one downloaded from iCloud at the time of the dump?
Well, there are quite a few differences. I mean, the physical dump of the device's memory will allow us to get much more information and much greater traceability of the file than with iCloud. And it's going to leave more records in case of any kind of indexing, alteration, or injection when it's done in iCloud. We run the risk, as happened to us in the lab test, of managing to insert a voice note into the voice note app. And when it comes to syncing, what about with cloud in the next operating system? And on the device, it already treats it as its own, and you would need to do a thorough analysis of the device in FFS to really see any kind of modification.
You've done that yourselves. It's possible. All right. Can Celebrity UFED distinguish in its extraction whether a file comes from the device's local storage or from a synchronization?
Are you referring to an idealized forensic examination or to the specific examination? No.
To yours.
The examination?
To this one?
Have you used that system?
Yes, Celebrity is a forensic program.
Of course it has been used.
Its use is common.
With the use of the system, have you detected any alteration, manipulation? Yes.
Of course, we only have the isolated files. We don't have the dump or the terminal to be able to use.
Have you detected anything?
Of course, we found inconsistencies in those files that were provided to us. All right, we would need access to the terminals or to that original dump to shed light on those contradictions we found.
Excuse me, let me clarify something. We haven't done any extraction, nor have we done any analysis with UFRE or with any other tool, and the conflicting elements were not found by us. The conflicting elements are only taken from the information provided in the police reports. Okay, what we have done is repeat test trials in the main laboratory regarding the capacity or in simulation of injecting elements into terminals. But that's giving us information about procedures that have been carried out for another case.
Yes, and I, Mr. President, have read the reports myself, even with my limited computer knowledge.
Mr. President?
If you ask me where I got it from, it's exclusively from this. And, sir, I have read the reports, and what little I know, read, and understand is what leads me to ask these questions. Anyway, I just get them from the reports here. Thank you, Mr. President. Next question. If the extraction was done from the cloud, can you guarantee that the file in the cloud is identical to the one that was on the phone at the time of the recording?
But to clarify the content of the question a bit, was any data obtained from the cloud? In the work you carried out, did you obtain any data from iCloud or from the cloud?
No. Specifically, we were only provided with the extractions from the devices. At no point did we have authorization to extract data from the cloud.
The question you ask is based on the hypothesis that data may have been extracted from a yes previously. Of course, that's not the case in this expert report.
Mr. President, it's just that I previously asked if they had extracted data and in some paths, right? What I understood is that what they explained is that there are some that come from iCloud. I don't know if it's necessary for you to repeat it.
They made a report and say that they extracted it directly from the data dump.
All right, Javier and Hernan, why do you say that some come from iCloud and not directly from the phones?
Well, what we are saying is not that, but that there are elements in the file paths, in the paths themselves. In some cases, the word iCloud appears, but we have to keep in mind that the iPhone ecosystem is linked to iCloud. So it's like a mirror. What we have on the device can be synced to iCloud, and what is on iCloud can be synced to the device. So based on that, we cannot determine whether they come from iCloud or from the device. And you have seen that in the path it says iCloud. It's in the reports provided by the police investigators.
All right. Once this is clarified, the analysis by the experts, 1 second.
Did you use the cloud or iCloud in your report?
In the dump that we were given, the only extraction was from the device. There was no cloud extraction.
If I may clarify this point, in the example we mentioned earlier, with the injection that we performed, from one iPhone to another, a voice note that we then synchronize to another device, that file comes from the cloud. Agreed, it appears as cloud in the path, but it physically appears on the last phone. Agreed, that is, the path on that device would be cloud, which would indicate to us, when analyzing that device or that dump, that it comes from, even though it is physically on the phone, that it comes from an update from a cloud synchronization.
But that's a simulation you conducted.
It's a simulation to provide answers to the questions we found in the files.
It doesn't address the content of the expert report under the terms on which it was commissioned to the forensic unit.
Of course, we found a series of data files, and we have to see why those paths are on those terminals, and what could happen if it's a file that comes from the cloud, the risk that entails.
Go ahead.
Yes, Mr. Javier, I think I understood that you, the iCloud point referred to in the reports, that you got it from the reports of that crime. Is that correct?
Yes, of course. I mean, let's see. There are routes. I don't know exactly in which of the reports, but there are paths that appear linked to iCloud. That's why we clarified that and explained it in the report. Keep in mind that before this court, as far as I know, one of the professional experts from the Civil Guard has stated this, please correct me if I'm wrong, that even one of several devices, or at least one of them, was linked to an iCloud account.
I think this point has been clarified. In the analysis carried out by the Civil Guard experts, some of the files came from prior extractions, while others came from the physical devices themselves. Is this distinction relevant to validate the origin of the audios? Yes.
It's not a matter of relevance, it's a matter of if the device hadn't had contact with the cloud, it would never have had those paths. In other words, it's inversely proportional. If we find that those paths are there, they can indicate many things. But one of the things they can indicate is that this device has synced with the cloud, and with that, we don't know for sure if that file came from the cloud, or if that file went to the cloud, or if it stayed on the device and was replicated in the cloud. So it's an indication that at least that device had been connected to iCloud, obviously.
All right, for the purposes of the following questions, so as not to make any mistakes, since this is my interpretation of your report, is it true that the hash of a file guarantees that the creation date, the modification date, and the content are authentic and original? Is this true?
No.
Can you explain what a hash is? There are many conclusions about hashes, so before we continue, could you tell us in simple terms what a hash guarantees?
Let's see. If I make a mistake about something, I ask my colleagues to correct me. Regarding the file, a file contains two areas. One space where the data, the information is stored, and another space where the metadata is. The hash guarantees the integrity of the data part. We can change dates and times without compromising the integrity of the files. Agreed? So, the hash calculation is an algorithm that determines whether a digital piece of evidence is in content identical to another. But the metadata showing the date and time can easily be modified without altering the integrity of the file.
Okay, so is it possible to modify the metadata of a file, like its creation or modification date, without altering the MD5 hash? Yes?
Yes, that's right. Okay.
If the metadata can be modified without affecting the hash, what exactly does the hash prove regarding the date and origin of the file?
Nothing.
Okay. If it compares the binary content of the file but not the time or the circumstances, can it be known when it was created? No.
No. What it guarantees is the integrity of the file, not the creation date.
Thank you. Regarding the internal databases and extraction from the cloud, what specific information does the cloud recordings database contain, and what does it allow us to determine about the origin of the files?
My colleague can explain it more clearly.
Mr. Hernan?
Yes. Basically, what we find there are system events, timestamp, offset, wall. I mean, that's what we find in that path, in that database.
All right. That database was thoroughly analyzed in the Civil Guard's reports, including the files and the rewrite history.
I don't know.
If the extraction comes from iCloud and not from the physical device, do the entries in the phone's internal databases reflect the original file or the file synchronized from the cloud?
No.
Can a restoration from iCloud or iTunes generate entries in the internal voice memos databases that are indistinguishable from those generated by a native recording?
Let's see. The only way to see that event would be by analyzing the device, the dump, and checking if there's a reference to it in that dump, which allows us to see a bit, go back and look at the events, the cycles that file has gone through. That would be one of the ways to verify it.
Okay. So, if you haven't been able to compare the hash values of the dumps from the Central Court of Instruction number 2 with those from the Supreme Court, if this comparison hasn't been made, can it be guaranteed that the files analyzed by the Civil Guard are identical to those found at the time of seizure at the home of Mr. Koldo Garcia Izaguirre?
To assess that, I'd need access to the devices or the dump. I couldn't venture an opinion on that.
Just two more questions. Do the custody bags used for the devices protect against radio interference that could alter the devices between seizure and the forensic extraction?
Well, as my colleague said, we don't know what kind of bags they use or what protocol they follow. Ideally, they should use Faraday bags to prevent any kind of connection or external interference that could affect the devices.
Well, and to the expert witnesses during the investigation phase before Judge Leopoldo Puente, I don't remember which of the two groups of experts, stated that they had not considered the possibility that those recordings could have been made with artificial intelligence. Do you confirm that statement, that this was not part of your report?
Yes. Within our protocol, we did not consider it necessary to examine whether artificial intelligence was involved because of the date of the files.
Well, there are no further questions. Thank you.
Thanks. One last question for the Civil Guard experts. In the event that someone, after receiving the audio files for you to carry out the assigned analysis, had injected some kind of compensation, some kind of document, some data or metadata, could it be detected? Would it leave a trace?
From the moment we receive the data, it enters the internal chain of custody of the forensic service, and then it has its hashes, and there are any manipulation, not the file hashes, those numbers that can be modified, but the hash of the complete copy of the hard drive that was obtained here at the Bueno.
Well, thank you very much. Yes.
Excuse me. Yes. Once we receive the extractions, we check the reports made with the forensic tools and verify that they have the same hash as the one we made on site in the same lab.
That is, the extractions made by my colleagues are the same ones that we have been able to verify as identical with the same hash.
Well, thank you very much. You may leave. The session is adjourned until Monday at 10 in the morning.